I
want to do that,
If
sir.
I need to send you mail, I need to know where to send it.
Right now, I do not have an address.
All right. Well, you do certainly have a right to represent yourself, and I don't have a quarrel with that. What do you want me to do? Set these for a trial? Or set a pretrial on all of these?
A sovereign citizen defendant strolls into court clutching a full-blown script, like he's auditioning for community theater instead of facing actual criminal charges. He starts reading it line by line, stumbling over half the words like he's never even seen the script before today. And it becomes painfully obvious, almost immediately, that this performance is not landing the way he imagined it would. The judge, who has clearly heard every sovereign buzzword, loophole, and internet law phrase in existence, isn't buying a single second of it. She shuts him down fast, with zero patience for the theatrics. And that's what makes this whole thing so funny. This guy genuinely believes these magic words are supposed to shield him from the law, like saying them out loud unlocks some hidden immunity. Spoiler alert, the law does not care about your homemade playbook, your YouTube research, or your dramatic reading voice. This is a perfect collision between fantasy and reality, and the courtroom is not a place where fairy tales get special treatment. And so now the real question is this: should judges let these offenders ramble until they hang themselves with their own nonsense, or should they shut it down the second it starts? Let me know what you guys think in the comments. Let's dive in and watch how this plays out.
David Zambrano.
How you doing today?
Doing all right. It's a Tuesday. We got lots to do, and we're making progress. Mr. Zambrano, we've had a hard time getting you in here. We got a lot going on here. In file 251521, you got a ticket on July 29th for driving without insurance and no valid license in possession. Those are both written under state statute. On July 25th, you got charged with driving with an unregistered vehicle in file 1523. On July 14th, you got charged with driving suspended and unregistered vehicle. That one's under White Pigeon Ordinance. So July was a bad month for you. Then we set this a couple times. The city, or the village of White Pigeon, in the July 14th case, has agreed to dismiss the charges if you plead to allowing another to violate the motor vehicle code. I'm not sure what the county's position would be on the other charges. And frankly, I don't know why they didn't charge him with driving suspended on all 3 days. Let's take a look. And then you'd missed a date, and then they reset it, and I don't know what happened, but
Your Honor.
yes.
I'm appearing here today, pro se, in the special appearance sui juris and in propria persona. I respectfully assert my rights to represent myself and have my constitutional rights recognized and upheld throughout these proceedings.
All right, well, that's certainly your right.
Thank you, sir.
You live in South Haven?
Actually, I'm a sojourner of the land. I don't have a residency at the
Well, the reason I ask,
I want to do that,
if
sir.
I need to send you mail, I need to know where to send it.
Right now, I do not have an address.
All right. Well, you do certainly have a right to represent yourself, and I don't have a quarrel with that. What do you want me to do? Set these for a trial? Or set a pretrial on all of these? Some are under White Pigeon Ordinance, some are under state statute. You can help alleviate this by getting insurance, getting a license. It looks like you have some out-of-state problems. and you haven't had anything on your Michigan record in a long time, 12 years or more. So how would you like me to proceed here?
What are the charges? Again, all the ones that...
Well, right now, you're not doing a very good job of representing yourself because you don't even know what you're charged with. Let me tell you again. You're charged with no insurance. That's a misdemeanor, punishable by up to a year in jail, a fine of not less than $200 and not more than $500. That was on July 29th. On that same day, they charge you with no valid license in possession, even though your license is suspended. They didn't charge that. No operator's license in possession is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. On July 25th, take a look at that one. No, that's the 29th. It's the same as the others. You got no insurance, no ops on person, unregistered vehicle. That was on July 29th. And those are all under state statute.
Look at this absolute disaster. I mean, this dude is literally clutching a script like it's his golden ticket out of reality. Whatever he spent printing that nonsense could have gone toward the license and registration he's going to have to pay for anyway. The irony is unreal, and it gets worse. He doesn't even have a valid address, which is step one for literally any legal document. So his entire sovereign paperwork stunt collapses before it even gets off the ground. Watching him fumble over words he supposedly rehearsed is honestly painful. If you can't even read your own lines without tripping over them, how exactly do you expect to challenge state law? Here's the real kicker, though. Yes, the Supreme Court says you can represent yourself, but only if you're competent enough to understand the process. And competence means a lot more than repeating, "I don't consent," like it's a magic spell. This guy can't even keep his own written argument straight, yet somehow believes he's about to outsmart a judge who's seen hundreds of these sovereign citizen wannabes. It's like showing up to a boxing match with pool noodles and calling it strategy, or trying to outwit a mechanic while holding the wrong car manual upside down. If you don't know the basics, you're not making a principled stand, you're just sabotaging yourself in real time. And that's what makes this so hard to watch. This isn't rebellion. It's self-destruction dressed up as confidence. Let me know what you guys think. Should courts even allow this level of unprepared self-representation? Or is this just proof that confidence without competence is dangerous?
On July 14th, you got another ticket. Take a look at that one. 1560. In that one, they filed a formal complaint that alleges that you were driving suspended and you had an unregistered vehicle. And that is under White Pigeon Ordinance. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. That carries 2 points and it requires that your license be suspended. And then they charge that you have an unregistered vehicle. You could help all of these if you got insurance, a registered vehicle, and worked on getting your license back. So one thing I could do is set all these cases for a pretrial on the same day with the White Pigeon Village attorney and the county attorney and see if they could come to some resolution of all the charges. Is that acceptable to you?
Actually, no, I have a few questions I need answered before we proceed. I don't understand the nature and the cause of this action against me. And I'm, is this a civil or criminal? It's criminal.
All right. You were here with your mom and she's here with you. So it's good that you support each other. She asked me the same question, which points out to me that you're not qualified to represent yourself if you don't know the difference between a criminal matter and a civil matter. These are criminal matters. They could result in a jail sentence and a sanction on your driver's license.
Thank you, Your Honor. Should the record reflect this is a criminal action then?
Yes, it is.
Okay. I just got to look at my papers and stuff.
All right.
So my next question about it is, Constitution grants this court two types of jurisdictions.
Yes. All right, we're not going to get into this, what I call Jabberwocky. That has no legal effect. I don't know where you get it or where your mother got it, from a online source or somebody that told you this, or they're giving you bad information. These are criminal matters. They're not terribly consequential. Normally you wouldn't go to jail for these, although they do carry a potential jail sentence. You don't necessarily subscribe to our system, but I certainly don't subscribe to whatever you got written on the paper there. I propose we set this for a pretrial, and you try to get a registration and insurance, and then come in and share it with the prosecutor and the city attorney, and see if we can resolve everything. If we can't, we can set it for a trial, including a jury trial, I suppose. It's two different incidents, so it would have to potentially be two different cases. What I propose is you trying to do some things to get situated and have a pretrial with the city attorney and the county prosecutor.
Your Honor, I'm going to have to object to that. I need, before we can proceed, I need to know, it's upon the authority of the Sixth Amendment, I need to know the nature and the cause of these charges. Now, could you tell me if it is a common law criminal
No, these are
jurisdiction?
statutory offenses written under the authority of the people of the state of Michigan. One of these is under the insurance code, and one is under the motor vehicle code. The others are. And I don't really wish to engage in this discussion. We've got about 40 other people waiting for their case, and you want to talk to me about how many angels can fit on the head of...
People really think they can just stroll into court, say a few magic words, and everything will disappear without ever addressing the actual problem. And this guy is the perfect example of that mindset. He literally tells the judge, "I don't understand the nature and cause of the actions against me." And the judge shuts that down immediately, because here's the reality. The Constitution guarantees that you'll be informed of the charges, not that the court waits around until you personally decide you understand them. That part is on you. And instead of fixing that, he spirals. At one point, he drifts off into some bizarre philosophical nonsense about how many angels can fit on the head of a pin, like he's trying to turn a criminal case into a college debate. And the judge throws it right back at him. Not to entertain it, but to expose how absurd the argument actually sounds in a real courtroom. That moment alone tells you everything. This isn't clever. It's not deep. It's just wasting time. What really stands out is how committed he is to sounding smart instead of being effective. Courts don't hand out points for creativity. They don't care about wordplay, loophole poetry, or pseudo-legal riddles. They care about what's legally relevant, what's provable, and what's written in black and white. And none of his rambling helps him with any of that. B.Y. choosing to represent himself this way, he's not taking control of his case. He's actively sabotaging it. Every sentence he speaks just reinforces that he doesn't understand the process he's trying to fight. This wasn't a strategy. It wasn't a stand on principle. It was self-sabotage disguised as confidence, and that's the real takeaway here. The court didn't defeat him. His refusal to engage with reality did.
Charged with two separate traffic offenses on two separate occasions. You have a right to have an attorney. I'd be happy to appoint one for you, but you don't want one. You want to represent yourself, which is your right, but you don't have the right to waste my time. So if you either want me to set it for a pretrial, I can do that. That would be my preference. Then you can sit down with both prosecutors, ask these questions, and see if it can be resolved. If it can't, we can set it for a trial, either in front of a judge or a jury. So what would you rather do here today?
Well, on the authority of the Sixth Amendment, I'm asking that the court discloses the jurisdiction that I ask.
I just did.
You said it's a statutory jurisdiction?
Yes, you're
Okay.
supremely unqualified to represent yourself in this matter because someone sold you a packet of information that has no relevance in the modern universe that we live in. So I'm going to set this for a pretrial.
Your Honor, that would be practicing law from the bench if you proceed without me.
I'm a lawyer. I'm a judge. I practice law from the bench. I do it every day, all day. And
I'd like to, I do have a few more questions about this.
I don't have any more time to answer your questions. I have a question for you. What do you want me to do with it? Set it for a pretrial or set it for a trial?
Under a statutory jurisdiction, I've never heard of, I need to know where I can find the published rules of the criminal procedure under that.
Well, you can certainly find them on, they're in the public library. You just put the number of the citation, 257904 under the Michigan compiled laws. All right.
Was that
Mr. Stickley is the chief public defender. He's had an opportunity to talk with you. Mr. Stickley, what's your recommendation here?
My recommendation would be to set it for a pretrial. I'm happy to spend a few moments with this gentleman and show him where the statute is and
All right.
where he can Google or library.
And he's entitled to have copies of each of the tickets and the complaints, and so he can see it. So if you'd like, we'll get copies of their tickets for you. You got the ticket, but there's a formal complaint. I'm going to set it joint with the city and county for 2 weeks, October 7. Mr. Stickley is the chief public defender, and he's not exactly representing you. He's here to make sure that your rights are protected. And he also can give you some advice and maybe point you in the direction of what you want to do. Again, it would be helpful if you would come in with insurance and a proper plate and perhaps an effort to get your license back. You don't want to stay on the driving suspended merry-go-round because it's very hard to get off of it. Once you get suspended, you live near White Pigeon. The other problem is I don't have an address for you, so I need a mailing address. When you go out to the, we can use your mom's address, but I'm going to need you to give the clerks some sort of address where we can send things to you.
Could you deliver it general delivery to the post office?
Well, you can give them that.
Okay.
All right. I'm going to want you to take him out, get him a proper notice for that pretrial on the 7th. Mr. Stickley will meet with you and get some of that information that you're looking for.
I think this dude was clearly unqualified, and honestly, I don't even know who filled his head with this nonsense. Watching him try to bend the court to his own little script is like watching someone pull out Monopoly money to pay a speeding ticket. It's amusing for about 5 seconds, but in reality, it's completely useless. The law doesn't care how confident you sound if what you're saying has no legal value. And the scary part isn't just how wrong he is, it's how much time and resources these stunts waste. Courts are already overloaded, and now you've got hearings being dragged out because someone watched a few internet videos and decided they cracked the legal code. Cases that should take minutes turn into drawn-out performances that help absolutely no one. What people forget is that judges actually do have the authority to decide whether someone is competent enough to represent themselves. Self-representation isn't a free-for-all. It comes with a basic expectation that you understand the process, the charges, and the rules of the courtroom. And when you flame out this badly, you're not proving the system wrong. You're proving the judge's concerns exactly right. IT really makes you wonder what this says about our society when people trust internet pseudolaw over centuries of real legal precedent. Somehow, confidence has replaced competence, and buzzwords have replaced understanding. That's a dangerous mix to S. Oh, I'm curious what you guys think. Should judges shut this stuff down immediately to protect the process? Or should they let these performances play out so everyone can see how badly they fail? Thank you so much for watching. Guys, take care.